CJI Ramana observes to the Attorney General Venugopal that the sedition law is a colonial law. It was used against freedom fighters. Is this law still required to exist? So, Chief Justice of India Ramana has made this statement asking the Attorney General Venugopal about whether there is a need to still maintain the sedition law. Let me go across to Meenakshi for more information on this. Yes, Meenakshi.
Well, massive observations and a very big breaking news are coming for our viewers from the Supreme Court. Remember, we are talking about the challenge to the sedition law where the Supreme Court had sought the assistance of the Attorney General, who is the top law officer of the Government of India. The Attorney General very much present inside the courtroom, inside the virtual proceedings, and massive observations coming in from the Supreme Court. No less than the Chief Justice of India questioning the purpose, if the sedition law indeed serves any purpose in the present date. He is making one observation after another. Crucial observations coming in from Chief Justice of India is saying, what is the purpose of having a sedition law that has been used in colonial times? It is a colonial law 75 years after independence. This is a law that's been used against Mahatma Gandhi. This is a law that has been used against Tilak. This is a law that's been used against freedom fighters of India. And to have this law continue in present date, what is the purpose? That is one question the Chief Justice of India has just posed to the central government. Secondly, the Chief Justice of India wishes to understand from the Attorney General about the accountability of authorities. Now, he is going on to make this observation, and I quote, "We do not understand why this law is continuing even 75 years after independence. There is misuse of this law and no accountability of authorities." Then the Chief Justice is telling the attorney as to how he is simply indicating what the bench is thinking. He is going on to cite the history of the usage of Section 124A of the Indian Penal Code. He is citing from precedent to say or remind the attorney as to how the attorney, if he studies the history of 124A of IPC, the conviction rate is very low and there is misuse of power by the executive agencies. So, four very categoric points being made by the Chief Justice of India to the central government. One, what is the purpose a colonial law is serving 75 years after independence? Secondly, what is the purpose this law is serving when there is such a low conviction rate under this section, and there is a propensity of misuse by the agencies, and therefore the Chief Justice of India is questioning the central government that this is a government that has repealed many stale laws. The Chief Justice going on to comment, and I quote, "I do not understand why is your government not looking into repealing Section 124A of the IPC, unquote." So with this, the Supreme Court has issued notice to the Government of India on a plea by a retired army person who is challenging the constitutional validity of Section 124A, which is the sedition law. So massive news coming from the Supreme Court where no less than the Chief Justice of India is raising the red flag on several aspects pertaining to the sedition law. And this is a challenge where the Attorney General is representing the central government because the Supreme Court yesterday had sought the assistance of the Attorney General in this present matter.
Right. Meenakshi, thanks very much for highlighting those very important points. Four points that Meenakshi just mentioned, which Justice Ramana, Chief Justice of India, has red flagged about the sedition law. Thanks very much for the updates, Meenakshi.